Okay, I'd like to welcome everyone to our first online Durham College Center for Integrated Justice Studies CPD Enrichment Night. And I'm going to tell you that there are a few things that have changed. The certificates of attendance confirmation will be emailed because we have to get the registration information for paralegals and paralegal numbers and make sure that there was an actual login for the Law Society. And afterwards, we are going, our live participants, we're going to St. Louis and Durham College in celebration of this. We'll be buying munchies and platters for the tables. I'd like to welcome Catherine Spurdy, my partner in business, and Leanne Moore, a wonderful paralegal with Cochrane & Moore, both experienced in WSIB, Workers' Safety Insurance Board, and presenting for us, Workers' Safety Insurance Board appeals process. And I'm going to let you go ahead. Oh, just one moment. We will be stopping every 10 to 15 minutes. We do have monitors for the chat feature. So we will be stopping every 10 to 15 minutes when they signal in order that we can have questions and comments from people who enter in the chat. Okay, participate.
Okay, so we are here, as Lori mentioned, to discuss the Worker Safety Insurance Appeals Tribunal and the Insurance Board. So we're just going to go through kind of a step-by-step on how you would begin a claim from the moment a client walks in. Typically, they will come to you with a decision letter that will be negative. You'll see on the first slide that I didn't hit, that you will have received a decision letter which has denied you a benefit. When you get that decision letter, you've spoken with your client, you've gotten their side of the story, you're going to get a direction of authorization, which you'll find just a few pages in if you're following us in person.
It's in your package. It's the first form.
It's 2 pages. The second page is really just an explanation. You don't have to send that. You just send the first page. And when you complete that page, I'm just going to skip ahead to it if I can. When you go through this form, the most important thing on this form is going to be the claim number. This claim number is going to be found on the decision letter. You're also going to need the worker's name and the date of the accident. Then you're going to fill in Part A, which is just up here. I'll hold it up, I guess. So this is Part A. This is the worker's information. Your claim number goes up here in the top corner. You need to fill in also your company information. Now, typically what we would do in our office is complete this as Cochrane Moore LLP, attention Leanne Moore. That way when I call into the WSIB, I can say it's Leanne Moore representing this individual. They pull up the direction of authorization, see my name, and we're okay. Or I can just put Cochrane Moore LLP, and then anyone in my office is able to call in and say, we're here on behalf of Cochrane Moore, and they can proceed. Now, with the direction of authorization, you will have to have your client sign. They're going to sign down here, and they're going to date it. Very, very important steps. When they come in, you're also, because you have a decision letter, going to complete an intent to object, which is the next form that you'll find, and I'm just going to scroll down again so that we can get to it. Yeah, I'm getting there. Is it the next one, or is
It's the next one.
Okay, sorry. So I've just been informed that our next form is actually the worker request for a copy of claim file. So we'll go there first. So the worker request for a copy of claim file is extremely important because this is what's going to give you a copy of the claim. A lot of clients will come into your office with a copy of the claim because someone else has ordered it before, or they've ordered it themselves, and they'll... She's just so busy. So they will come in, and sometimes they'll have a copy of the claim. Anyone who's worked in WSIB, you know that these claims can be huge.
I just got one today in the mail. It came in a box. It's this big.
Yeah.
Okay? Literally, that's the file.
So when you get a copy of the claim from your client, realistically, they've ripped through it. Someone else has ripped through it. Sheets are out of order. Things are potentially missing. Nothing is going to be the way it would be if WSIB sent it to you directly. There's no charge for requesting a claim file, so we always request a fresh claim file and ignore what the client has sent until that next copy comes in. Realistically, there's no point in wasting our time going through a copy that's potentially missing documents. So the worker request for claim file is very important. Again, you must have the copy of the claim file number. If your client comes to you without a decision letter, you can still request a copy of the claim, have your client call, get the copy of their claim number, and WSIB will just give it to them over the phone.
They need their social insurance number.
Yeah, thank you. Because they'll have the information required. You're not going to be able to call at this point because the direction of authorization has not yet been sent, so you're not authorized to act. The client will have to call WSIB. You'll fill in the claim number. You'll again fill in the client's information. Now, on this form, there are two boxes. There are two options. The first option is to have the copy of the claim sent to the client. The other is to have it sent to a third party. We always want it sent to a third party. The third party is our firm. So we're going to fill in our contact information at the bottom. That way the claim is coming to my office, and I don't have a client who's potentially in St. Catharines calling me to say it's at my door. And now we have to drive to St. Catharines or have it mailed. So always get it sent to yourself. Then you're going to go to your intent to object form. Now, the intent to object form, the request for a claim file is one page again. The documents are very simple. They're very easy to fill out. So when you get to your intent to object form, this is where you're going to have the decision letter again. You're going to look at your decision letter. Again, claim file number, worker information. When you get to the bottom of the page, the lower portion, right here, you'll see Catherine has filled it in as a sample for everyone with her company information. Up at the top, obviously we can't put any client information in because it's confidential. But when you get a little bit further down, you'll see intent to object under number 5. So here, you'll take the letter that your client has brought to you with their decision saying you're no longer entitled to trazodone. And you'll put the date of the letter, and then you'll put the issue that you're objecting to. Now, the decision letter from the WSIB is going to have a regarding line, and that RE line is going to tell you denial of psychotraumatic disability, denial of
Medical marijuana.
anything.
Because that's prevalent on my mind right now.
So you're going to just put simply in here, you're objecting to the decision letter of January 2017, and it's going to have the issue in dispute as objection to the medical marijuana, because we really want that. Then again, you're going to get everything signed and dated, and get that out to WSIB. With these forms, what Catherine and I would both strongly recommend is that you do not mail them. You fax them. If you mail them, it's going to end up in a mailroom, and you're going to have any number of people misplace it along the way. If you fax it, you have a fax confirmation page. You staple everything that you have faxed to the fax confirmation page. You double hole punch, you slip it on your brads, you put it in the client's opposing or WSIB folder, and now you have it. Because in 2 to 5 days, you're going to call WSIB and you're going to ask them, did you receive the fax I sent over on March 30th? They're going to say, no, we didn't. You're going to read back all the dates and relevant information, and then they're going to find it.
I've had to use my fax confirmation sheet before to prove that I did meet a deadline, because deadlines are important. And if they say that you did not meet a deadline, then you could actually have an E&O claim. So those fax confirmation sheets are extremely important to show that deadlines have been met.
Your deadlines with WSIB are typically 6 months. if it's an initial objection. So when a client comes to you with a decision letter, the decision letter is going to tell you what your deadline is for that objection. And you need to make sure that you tickler that right away, and someone in your office gets an intent to object out to WSIB to make sure that you meet that deadline. If you miss that deadline, like Kat said, you could be open to an E&O claim. Also, we're dealing with WSIB. These are people who are already suffering. They're off work, they're injured, they have a lot going on emotionally and mentally, probably familial relationships that are being disrupted. The last thing these people need is for someone who should know better to miss a deadline. So those are extremely important. I say it's typically 6 months. When you're doing a return to work or a work reentry, you have 30 days. I said 3 months. I don't know where that came from. You have a 30-day timeline on those. And this is all outlined in the WSIA, so you can go through and you'll find everything that you need in the Act. It's very, very clear. And I think I'm going to pass this to you if you want to carry us through appeals.
All right, so let's look at the appeals readiness form.
Do we want to stop for questions?
Do you have a question?
Do we have questions?
I have a couple things I forgot to say. So we'll just cover them. Yeah. We haven't had any questions. If you have a problem seeing it because of Flash Player, but I think everyone solved that on the chat. At the bottom right corner, there is an option to download the materials. It's called Resource Library, and everybody online, if you can please click on the Resource Library, you can download the materials, and then you can print them and save them for yourselves. I'm not sure if I mentioned, this qualifies for the time period for substantive hours. And it is up to the paralegal to claim those hours and qualify for those hours with the Law Society. We can't guarantee that. Okay, so that's why we have the qualifier that it may qualify. And the last thing, I just wanted to mention that some legal clinics run by Legal Aid in Ontario do have paralegals who represent people who income qualify in WSIB. And a lot of people will income qualify, and if you do not practice WSIB currently, or there's a case that it's I don't know, not in your best interest to take, you may want to refer the people to your local legal clinic or the local legal clinic closest to that person. So that's another thing that I wanted to make sure of. And Catherine, if there are questions, we'll interrupt again in 15.
All right.
Okay.
Any questions from you guys so far? Nothing? Okay. I'm going to take you through to the appeals readiness form. So prior to 2014, we used to get what was called a 60-day option form, which was really, really great because you could send it into WSIB to the appeals branch, and then they would have 60 days to make a decision based on the submissions that you have submitted or with the information that's contained in the case file. They don't do that anymore, which is unfortunate because I really liked the quickness of the 60-day option form. So we now do what's called an ARF, an ARF, an appeals readiness form. And one thing you'll learn about WSIB is that everything is an acronym, so you might want to start keeping track of the acronyms when I talk to you, okay? I'll explain what every acronym is. So your first one is the ARF, the appeals readiness form, okay? There's no time limit to submit your appeals readiness form. Your time limit is on your intent to object. So you've made your objection known. You've sent in your intent to object within the 6 months time limit. Now you can send in your appeals readiness form once you've collected all the necessary medical evidence, whatever it is that you need. Okay? The nice thing about the appeals readiness form is it only needs a signature of the representative, so you don't have to bother the injured worker when you are trying to get your submission submitted. I have an injured worker right now. I just did his submission. He lives in Nova Scotia. Okay, can you imagine how hard it is to get him to sign things? So yes, I like when I can do the signing on my own. Okay, this part. guess the best thing to understand is that WSIB has 3 tiers. It has the board, it has the appeals branch, and then it has the tribunal, which is totally separate. So we are at the appeals branch right now. The appeals branch being the internal appeals board inside the board that's going to look at the decisions that the board has made, okay? Has nothing to do with the tribunal, so that's where we're at the board part. So what you are going to do is fill out the appeals readiness form. Then the operations intake team is going to receive it, review it, check to make sure that the case is ready to proceed, and then forward it to the appeals branch. From there, okay, they will see if there's a reconsideration that they can offer at that time. If not, they're going to forward it on to an ARO. ARO stands for an appeals readiness officer, okay? And he is the person who is going to make the decision on this file. So looking at the appeals readiness form, it's a pretty straightforward form. Okay, it's 2 pages. It always comes with your claim file. Once you receive a claim file, it will have a letter on the top from the access team telling you that this is the claim file and that you will never receive another one. You'll only get updates. Okay? Don't believe them. They'll send you another one if you need it. Okay? Once you get the file, sorry, I have a tea here, it's just cold, sorry. Once you get the file, this appeals readiness form is going to be the 2nd, 3rd, 4th sheet inside the file. You're going to want to take it and make photocopies of it, because trying to get another one from the board is very difficult, okay? So make photocopies of it. It's double-sided. Make sure you make lots of photocopies. If you make a mistake, you've got a new one, okay? It's pretty straightforward. Fill it out on the computer. You will see in sections, well, we have them backwards. Page 1 is over on the left, or on the right-hand side. Page 2 is on the left-hand side. So starting on page 1, general information. Okay, coming down to the part 3, let's start with appeals 2. Okay, all sections must be completed before the claim is ready to go to the appeals branch. They want to make sure that you have no outstanding issues. Okay, so yes, all the information has been submitted. All right. And then you're going to say, no, I do not object to the release of the medical information to my employer. If you have some issues with that, there is another form that I will show you in which you can designate to the board what documentation you do not want disclosed to the employer. Okay? Then you're going to talk about your issues in dispute, filling it out. Okay? What are the letters, the date of the letters that you're appealing in this submission? Then you're going to explain your submission. My position on this issue. You don't have to put in submissions if you don't want to. Your written submissions are to aid the ARO in making his decision. If you want him to just to read the file and make his decision based on the evidence in the file, that is something you can do. You can just put in there that everything is contained in the claim file, or you put on there how many pages of a submission that you have submitted. Okay? There's an area for representation. Going over to the second page, you're going to ask him whether you want an oral hearing or a hearing in writing. For the most part, AROs do hearings in writing. Very rarely do they offer hearings in person anymore. It just streamlines the process. They can do a lot more hearings quicker if they do them in writing than actually having people come to the board. Okay? If you were looking to take your person to the board, your injured worker, you have to explain to them why. What is it that you need? That an oral hearing would be better than a written hearing. Why do you need an oral hearing? If I had a injured worker who was, for example, I have a very injured worker who walks with 2 canes and is bent over and can hardly move, yet they think he can go back to work and be a truck driver, right? So when I take him into the board and he can barely walk, then they can say, how is this guy going to ever be able to be a truck driver? He can't get into a car, let alone climb an 18-wheeler, right? So things like that. But if I took myself in, okay, because I'm an injured worker myself, do I look injured? No, right? Do you think I would make a good witness going into WSIB saying I can't work? But I have a whole person impairment of 31%, and I'll explain that to you in a minute, okay? 31% is a very high whole person impairment, okay? So taking somebody like me into court might not be a good idea, all right? So it would be a better idea to do a written submission. Any questions so far, guys?
Heather, just one point on I should have raised it on the intent to object. You
Yes,
mentioned
dear.
reconsiderations. Mm-hmm. You can do a reconsideration on your intent to object before you even do your appeal.
Even before you do it, you can ask
Depending on the matter, if it's
Yeah.
something small, for
Your-
example.
your case manager, you can do a reconsideration as soon as you put in, if you have updated medical, anything.
Statement, if there's no proof of facts.
Anything, you can get a reconsideration at your case manager before you go. Yes, you're right, thank you. Was it Jordan?
Yes. I see here that there's a limited amount of space for writing. If you need more space, would you attach schedule writing?
I attach 15, 20, 30, 40.
120.
pages. Yeah. Yes, Matt, right?
I know you're talking about written and oral hearings and that it's ultimately the discretion of the WSIB to make that decision. So if you're, say, for example, you agree that it's written submissions, you think it'd be advisable in that situation to attach your written submissions to the appeal readiness form or wait for confirmation from the WSIB that they plan to go that way?
It depends on the case. Like if I'm looking to get an oral hearing, and I really, really want an oral hearing, I will send my appeals readiness form in, and the submission is why I want an oral hearing. I wouldn't submit my written submissions into my position at that point.
But if you were requesting a written hearing,
Oh, if I'm
wanted one.
requesting a written
right,
hearing.
would you include that in the appeal readiness form? Because there's always the chance they may come back and say, well, we don't want it by written hearing, we actually want it by oral hearing, and then you wasted all that time
No,
producing submission.
I submitted anyways.
Realistically, those written submissions will be useful when you get to the oral hearing. So it's not going to be a waste of time. You're still going to have your notes pinpointed. You're going to need to go through your binders,
All preparation.
binder. So rereading it, rewriting it, it's not going to hurt.
And just, you can save yourself time from having to do a case history and a lot of other stuff that otherwise.
I know.
But yeah.
But it's preparation.
With some clients as well, I mean, we have claims that date back to 1987. So if a claim is dating back that far, the timeline on that claim is going to be huge. When I go into the WSIAT, I want a timeline and a case history there. So it's not a waste of my time to do it. Realistically, I'm doing it as I'm reading the file anyways. I don't usually wait for a written portion to assemble that.
Yes,
I
Laura?
have a question or a comment, if you want to elaborate on it. It's from Jesse. I was told that a reconsideration can be completed once in a 12-month period for the same issue. I was just told this today by a WSIB manager.
A reconsideration, is you talking about a non-economic loss reconsideration?
I don't know, Jesse, what kind of reconsideration?
Because if it's for a non-economic loss, it's once every 12 months.
Okay, so we'll clarify with Jesse.
Okay.
Okay? Is it a no?
Yeah, non-economic loss would call it a NEL.
A NEL, a non-economic loss. It's an award given to an injured worker based on their limitations and their restrictions, okay? So they'll go, it used to be that they would have a physical examination. Very rarely they send them for a physical examination anymore. It's mostly done on papers with range of motion tests, objective MRI, CT scans, doctor's reports, and then they rate your whole person impairment based on the American Medical Association guidelines. Okay? So, for example, a person with a back injury might have an 18% NEL, non-economic loss. Okay? And it's given to them kind of as an award for the suffering that they will endure for non-economic, not their loss of earnings, their LOE, but for out-of-pocket expenses that they would have suffered as a result of the injury. Okay? Any questions, guys? All right, so there are some other forms that you're going to get with this. There's a participant form. So once the board has received the intent to object form, the board's going to mail a participant form over to the responding party.
Oh, I just think the objection to employer next.
Sorry?
I think the objection to the employer is next.
I'm just going through my slides.
Oh, I'll go back up to your slides. Sorry.
That's okay. Then there's the respondent form. Okay, the respondent is sent to the responding party. They are going to send that to the objecting party, letting them know that they are participating. Okay. Moving on to the oral hearing.
Nope. Not even close.
Page 91.
All right.
We talked about reasons that you could get an oral hearing. If you go to, I got a link on the website for the policies and procedures in the Appeals Service Division. If you go into that link, there's a list on page 14, which will give you a suggestion of what type of hearings are going to garner an oral hearing. Okay? And hopefully, after an oral hearing, you are supposed to receive the decision within 30 days. Doesn't always happen. Okay? Doing a hearing in writing, like I said, I do these all the time. I actually prefer to do them. I write well, so I prefer to do them. Okay? So your ARO is going to make a decision based on the information that is sent in by the parties. Okay? So the objecting party, whether it's the employer or the employee, is going to send in their appeals readiness form along with their submissions. That's going to be sent over to the responding party. Okay, so for example, I sent in my submissions for my injured worker. Those submissions are going to be sent over to the employer rep, and the employer rep gets a chance to respond to my submissions, sort of like cross-examination. Then I get the chance to reply to his submissions, okay? It's very similar to redirect. And when it's all submitted, I get a letter saying all the submissions have been submitted. They will forward it to a legal worker, an ARO, and then I will wait for a decision. How long do I wait for a decision? Months and months, okay? Unfortunately, the board is so busy right now with appeals that the appeals branch has just suffered a tsunami effect of appeals, okay?
As Kat mentioned,
Oh, yeah, sorry, Deanna.
As Kat mentioned with oral hearings, sometimes it's great to have your client come in because your client, in appearance, will assist your case. Sometimes your client is less sophisticated and sometimes says the wrong thing. A written hearing is fabulous because you have full control over what is sent to the board. You don't have to worry about what your client is going to say. And as Kat mentioned, then you have an opportunity to respond, and sometimes your response can be, it just strengthens your case depending on what the employer has sent back and whether or not they have a representative. I'm sorry for interrupting you.
That's okay. No, we interrupt each other a lot. Okay, so preparation is key. You have to know your file inside and out. Okay? And you need to know exactly what your issues are, what objective medical you have to support your issues, what it is that you're asking for, understanding the policy and the procedures of the board, their policy and procedure, the operational policy manual, understanding the act, and then knowing what to argue to get the best for your client. Okay? So you want to know, is there a medical diagnosis of a workplace injury? Just because somebody got hurt at work doesn't mean that it's a workplace injury. I had a client who was doing paperwork on her lunch hour. Not anything special that she had to do. She was just doing paperwork on her lunch hour. She stood up, fainted, passed out, hit her head on the table. Concussion. Is it a workplace injury?
Yes. I would say yes.
Why, Alexi?
What kind of paperwork? If she was doing something for herself, so no. But if she was doing something for the boss,
She was doing something for herself.
for herself,
For herself.
So
what do
it's
you think? No, right? Even though she was injured at work,
What about the presumption clause?
the presumption, what about it?
What about the presumption clause?
Yeah, go for it. Presume that she's injured at work just because she was there?
Well, you're in the course of and then arising.
But she wasn't in the course of her employment.
But she was in the course of employment. It was a break, right?
No, it was her lunch.
That's what I mean. So
Yeah.
In the course of her employment, then it's presumed to arise out of, no?
No, I would argue it. Let me tell you, I argued differently for her. But I did lose. it was deemed that she did not injure herself in the course of her employment because she was doing paperwork for herself and not for work. If it had been workplace paperwork, it would have been a different story, but it wasn't.
But let's say she's sorry for the scenario, but she's filling in some forms, and it happened to be that some of them for
Then it would be
herself,
different
and like,
because then she'd be getting injured in the course of her employment. If maybe the paperwork made her dizzy and that's why she passed it.
You have to remember as well, they have full discretion. So a decision that Catherine received may be different than a decision that Alexi received.
Because
It's a different adjudicator and they feel differently and exactly. Interpretation is everything with them. You have to argue adamantly for your points, and
basically the best lawyer wins, like this phrase.
the most persuasive advocate. Yeah, it's completely at their discretion. It's written into their act.
It's very frustrating, to say the least. It is very
It's just
frustrating.
like judges, does the adjudicator know the rules and the law and the guidelines?
Don't get me started, Lori.
Okay, so
I'm still fired up. Don't get me started.
objective medical evidence is the key, okay? They don't want subjective medical evidence. Subjective meaning doctor's opinions. I have a wonderful doctor who will let me write whatever letter I want and they will sign it and I can send it out, right? But the WSIB knows that that doctor has a personal relationship with me and they're in support of my injury, okay? Objective medical evidence is what they want. They want MRIs, they want CT scans, they want tests, range of motion tests to show that you can't do the work that you can no longer, or that you were doing beforehand, okay? So do you have that objective medical? And if you don't, how can you get it? When can you get it? How fast can you get it? Okay?
That's also extremely frustrating because that medical is going to go to a case manager who they're not a doctor. They don't fully understand the diagnosis, and they're going to argue that it's not related, or they're going to argue it's pre-existing. And it's your job then to prove to them that it is relevant and it is all related. And that's extremely frustrating and sometimes feels like you're banging your head against a wall because you're talking to people who don't fully understand the medical side of things.
Just remember that it's the quality of the medical that is important, not the quantity. You can have 15 doctors' opinions saying, yeah, you can't bend over, but show me one MRI that has a herniated disc at your, I don't know, your L4-5, then definitely I can say, no, he can't bend over because of this herniated disc, not just doctors saying, no, he can't bend. Okay? So it's the quality of the medical evidence that shows the injury. And then identify. Make sure while you're preparing, identify any information that is missing so that you can get it. Okay, I just went through a file and I had to go through the doctor for 5 different medical papers because they were not included in the board's file. Okay, they're referred to in the board file, but the medical was not included, so I had nothing to review. So I had to go to the doctor to get them. Okay.
That's another reason we fax. I send a detailed list to the board and I say, please forward me the following documents only. We underline, we bold, we capitalize, we list point form, everything that's missing. If it's a Form 8, which is what the doctor would fill out, whether it's a letter that's referenced that isn't included in the materials. So this claim file comes in, you need to make sure you know what should be there so that you can find out what's missing. And then you're going to send a letter by fax to WSIB and say, please send me these documents. Likely you're going to end up with a second full copy of the claim file, or a third full copy of the claim file, sometimes even a fourth. So this is where communication with them is very important as well. You need to be constantly communicating with the case managers. So if you can get the case manager to work with you, it's going to make your life a lot easier.
Okay. So becoming hearing ready. Okay. Read the guidelines. Read the practice and procedure guidelines. Understand what they are there. Okay. what they're there for, what the guidelines will support you with.
I'm terrible with the slideshow. I'm sorry.
That's okay.
I'm
Review
constantly
the
2 pages
operational policy manual. The OPM is found on the WSIB website. You can look up all the different policies. Okay? Argue those policies. Break it down bit by bit and argue why your case is similar to that policy and why that policy should be applied in this situation. Okay?
There are also medical discussion papers posted on the WSIAT site. You can read through those.
Definitely.
Most of them are dated 2002, 2006. So make sure you're going through those, finding things that are going to be helpful to your case. Also look for things that are going to hurt you. You want to know what they're going to say to you and what they're going to question your client about.
Okay. Research decisions. The appeals branch doesn't necessarily have to take any decisions into consideration when they're making a decision, but I always send decisions in anyways just to show them that what the WSIAT is going to say when we get there. Okay. So definitely have some decisions. Reading decisions, case law is always beneficial because it might support some position that you're trying to argue and then lead you to another case that is a little bit stronger. And then prepare your theory of the case. Get ready to argue, okay? So when I do my structure of the hearing, I review the facts of my case, keeping my case history brief, just explaining the injury, how the injury occurred, the causation of the injury. From there, we set up the issues. What's the reason for the appeal? Why am I here? What am I asking for? Okay. Then I always review the evidence that's contained in the case file. You'll get a nice case file. It'll be nicely bound for you. Oh, it won't be bound until you get it. Okay. From there, I go to the law. I argue the law that's going to support my position and any policies that I want to support my position. And then I go through my conclusion, telling the ARO exactly what it is that I want from him, and hopefully that he will give me my decision, the one that I'm looking for. Okay? If you're doing a written submission, you want to keep it clear and concise. Remember that they're reading them. So try not to go into too much flowery language. They want to get to the point, get to the issue, so I can keep it, get to the decision. Okay? You want to make sure that your client's name and claim number appears on every piece of documentation that you send, and number it. Always number using the bold number, so it says page 5 of 100, so they know exactly how many pages are coming in. Okay? Proofread, get someone else to proofread for you. Okay, that's where Leanne comes in. Okay. And then once I'm done, I always ask the other party that has read for me, does it make sense? Would you find in my favor? Okay. If you're going to an oral hearing, be aware of traffic. Right, Leanne? Right, Alexi?
And Tim Horton stops.
Okay, traffic, if you're trying to get into Toronto, and, you know, you have to be there for 9 o'clock in the morning, and it's now 7 and nobody's on the road yet because we haven't got through. So be aware of traffic, okay? Get up early, get ready, get going. Have your phone number for the tribunal or the board on auto dial, and know your case number. Have it on a Post-it note and stick it on your car, okay? So that if you are stuck in traffic, you automatically dial, I'm calling about claim number 2366778, okay? And then you can just tell them that you're on your way. Could you please just stand down? We're just stuck in traffic, okay?
We were on time that day.
We made it just in time. What else can I tell you? Well, we wait for our decision. Your decision is something that you will wait for, and you'll be so excited when it comes because the perlator will bring it, and you'll get to sign for it, and you'll rip it open, and the very first thing you do is go to the last page, okay? Because you don't care about anything else except what the last page says. The last page is going to tell you whether you're successful or if you were not successful, okay? If you were successful, congratulations. If you weren't, I'm sorry to hear it, but your work doesn't end there. Okay, there's always the tribunal to go to now. So there's another step, another kick at the can. If you were successful, your work is not done though, because now comes implementations. And implementation can be just as lengthy as waiting for a decision, getting things implemented. I've had a client that I got deemed competitively unemployable because he's at a 66% now. That's amazingly high, okay? So that was in November. I got him deemed competitively unemployable. I'm still waiting for him to get paid, okay? That's how long it takes.
There's another slight difficulty with WSIB, in that typically you'll take your clients, if they're workers, on contingency because they're off work and they can't afford to pay you hourly for the next 4 years, sometimes 7 years. It can take a really long time from start to finish. So these people can't afford to pay you hourly. You're typically going to take them on contingency. Now with this board, they won't pay you directly. If you go to small claims, you can request that the money come to you, and then you can disperse it out to your client after you've taken your percentage. Here you can't do that. They're going to send the money directly to your client, and then you're going to rely on your client to pay you. So you want to make sure that your 4-year relationship with this client is very good, because you want to make sure that that client will pay you. And I've heard from others, it hasn't fortunately happened to me, and I don't twice with you. Okay, that's pretty good still. It happens, you don't get paid. The client takes off, they think payday, they just got 20,000, 40,000, 200,000, and they're gone, they don't need you anymore. So you want to make sure that you keep a good relationship with these clients even after the decision has been made. So you want to make sure that you get that paycheck.
But can you sue them then?
Oh, you can get judgments, but then they have judgment proof. And good
Because
luck
they've
getting
spent the money.
So,
They've been off work for 4 years.
so yes.
They don't have that money
There's
anymore.
$20,000 out there owing to me. Will I ever see it? Probably not.
Not if they win the lottery or something.
Yeah.
We just have a question from the online chat. From Ed Woods, he said, within the WSIB field, what is a typical contingency?
I think it depends on the client's case, really. We're usually, typically 30% would be high. We would take normally 15 to 20 because we're bleeding hearts. But I know most people are taking the same as you would with most other files. They're taking 30 to 33%.
Thank you.
Counselor, are you 20 to 25? We're 25.
25, okay. I'm a way bigger bleeding heart than she is.
Can I say one thing about contingency? Mm-hmm. I was at a meeting at the Law Society, I'm losing track of time, yesterday, and they were talking about 2 regulations. One the Law Society is working on and one the government is working on. Now, the one is referral fees. I'm sure all paralegals are aware of it. The other one is contingency fees as they relate to motor vehicle and SAPs. However, having said that, I was talking to the president of the Trial Lawyers Association because they are vehemently fighting this because the proposal is 15% cap on contingency. That's going to greatly affect access to justice in SABs. And what the Trial Lawyers Association didn't realize is a significant number of paralegals work on contingency in small claims court, HRTO, and WSIB. So I'm going to try to meet with them, and we're going to put together a submission that 15% is much too low, and I believe it is, and it will affect access to justice in Ontario because people will not be able to get representation. So that's another thing going on at the Law Society right now with contingency fees, and we all know the actions of a few ruined it for the many.
With us, Lori, we adjust our contingency fee based on the amount of work that was done.
Yeah.
And we adjust it also because I do our billing.
I know you do.
We also adjust, and I will say down,
We down.
depending on the stage that the person is at. When
Yeah.
Catherine and I became partners, I didn't know anything about WSIB, and I was shocked at the different awards and the amount of time some of these cases that she brought in were 3 and 4 and 5 years, 6 years old. And that's because, yes, the decisions came in, but there were other awards along the way that happened. So that's why I said, I know our standard contingency isn't 20%, but I do know that depending on how much a person has paid, what stage the person is at.
That's right. And if I
often
just wrote a
the-
letter, I can't justify charging 25%
Right.
for just writing a letter, right? So no, it's different for different causes. Sorry, honey.
What about a fee to take the initial claim? So you mentioned the worker comes in with a file in an anchor's box. You said, would it take X number of hours to review that file and decide whether or not you can advance the claim?
I know a lot of paralegals who do that. I personally don't work that way. As you know, being an injured worker, I know what it's like to not have any money and to go and try and have someone look at your case for you and not have that $500 that they want for the initial file review fee. So it's not something that I personally charge.
I've only ever done that once. And he showed up with a banker's box, and then another banker's box showed up. So I did charge for an initial file review. With that file review, though, I did get a copy of the claim file sent over as well, because his was very jumbled. So that included the 2 banker box review plus the WSIB review. And we're still fighting to get missing documents from them. So I don't feel that I've wronged him by charging this, because it's been a long process just to tell him whether or not it's worth pursuing. But typically we just do a review. We know kind of what we're looking for. I'm not going to read the entire claim file. I know which decisions to go to and to tell you, you missed your deadline on the ITO and we can't help you. So.
Any other questions? Do you want to talk about your cases?
Sure. So, sure.
Because we have time.
Sure.
And I have a couple of announcements. I'll come over there so we don't go. I have a couple of announcements for everybody. The Bonkela, as everyone knows, I'm a broken record. I've been to 2 meetings at the Law Society now regarding the Bonkelo submissions. The Law Society Treasurer and the Attorney General are begging for submissions from the public and submissions from paralegals, students, anyone, lawyers, anyone who is or could be affected by access to justice with regard to family law and those who earn too much money to qualify for legal aid, however, do not have enough money to pay for a lawyer, and something in between. So there is a Gmail email group. I will be on the weekend sending updates. There is a Facebook group. It is a secret group. You have to PM me for that address, only because we do want to monitor who is on that group and who is on the emails, because there is a lot of opposition.
No
and
spies.
We have a strategy with regard to submissions. So that's Bonkelo. Those submissions are due May 15th. I do know some of the paralegal networks and OPA have a considerable number of submissions from the public, and everybody I talk to, like today, I think, yeah, during my conversations, I have 3 additional. So if I do even 3 additional every 2 days, that's a lot of submissions from the public saying we need help. So that's Bonkelo. The latest date for Attorney General and Law Society is May 15. Email me. You have my email at Durham College, or you can Facebook PM me for the information or to join the groups. I did not say thank you to Lon Appleby who is absolutely amazing with the global classroom, both in generosity of time, use, everything else. This has been a huge endeavor for me because I'm not a tech person. We have technical people at the Bridge in Toronto monitoring this this broadcast, and I just want to say thank you very much because I don't meet these people, and but they're there.
I'm learning how to argue the law.
You're learning how to argue the law. Very good, Lon.
Down, quote, argue the law.
And access to justice. You were in on the initial meeting.
There you go.
I would like to say I didn't want to confuse anybody with my Facebook post. There is going to be a Durham Community Legal Clinic annual, Matt, I'm sorry, I don't have the flyer. It's the annual, it's a CPD, it's a day-long education session.
The housing forum, or
Housing,
sort of,
is that the Housing Forum
Housing
mid-May?
forum. You have to forgive me though. I have no idea. What
Okay,
actually
it is the Housing Forum. Thank you very much. And I will be posting now the information on the Durham College CIJS Facebook group. I will be posting it on, maybe Lon and I could post it on the Global Classroom site. Anyone who does landlord-tenant, I'm presuming we had big changes that came out today. I do not practice landlord-tenant. Don't ask me what they are. They're big though. So there are community legal workers in landlord-tenant, lawyers in the community. So I'm presuming that there will be a wealth of information. It is very inexpensive, and I will post
$15?
$10.
15, I think.
10 or 15.
Yeah,
I will post the cost. I will post the flyer everywhere and plaster it on Facebook. And next month, our CPD is MPAC, Municipal Property Assessment Corporation and Assessment Review Board, presented by Drew Samuels. Drew is a graduate of Durham College. He is faculty member, and he is now a manager and AIIC. So you can look him up on LinkedIn. He is not on Facebook. And he will be presenting, and hopefully, because we have all the information ahead of time, we will be releasing the horrible introduction that I have to tape every time. Introducing the
Not bad. First time.
the topic and what will be covered. I will look up the professionalism hours. This one is substantive, but I'm almost positive that one is substantive and procedural. Please book these evenings for the third Thursday of every month, 6:15 to roughly 9 o'clock p.m. And we'll take a break till 25 after. Is that good? Okay. And if there are any questions, bring them in on the chat or comments. Okay. And thank you for your patience this first time around.
Oh, I'm killing this slideshow. I'm like three pages.
Hi, Brian. Can you hear me? Sloan.
Hi, Lon. Yes, I can.
Great. Okay. We're breaking until 7:30. So I'm just thinking in terms of, and then we're going to finish. We're going to go till 9 o'clock, and then or 8:40. Lori, is it 8:45 you end? Or 9 o'clock, the class? 8:40, between 8:45 and 9. Will there be another break? Okay, yeah, sorry, go ahead, Brian.
I only have it scheduled until 7:30. I mean, obviously, you know, if you guys are connected, you have to give it notice if you may go this late. Because, you know, yeah, but anyways, yeah, just let me know.
It should be the class. I never gave anything till just 7:30. I don't know how that was.
The 6 p.m. for an hour and a half. Is that not what was requested?
Oh, no. And I think what happened is because there's an expectation that a global class is just 90 minutes, then it was assumed. I should have clarified that this is going till 9, not 7:30.
Yeah, okay. Well, in the future, just, you know, you can clarify how late you
Sorry.
Fine.
Are you okay? I mean, whatever, if it's overtime or whatever, we'll handle it. We'll pay for it.
Yeah, no way, guys.
Okay. Yeah. So I'm sorry about that. I should have. Anyways, I'm okay. In terms of what sits up on the webcast now, I can just mute, and you can leave if you want the image of just the classroom of people in the background like this.
Yeah, if you want to turn off your slides, you can do that as well.
Okay. Yeah. Why not? Just leave it like that for now. I mean, we do have a holding slide. Do you have access to the holding slide?
I wouldn't be able to turn it on. We have people on the live stream.
Okay. So just I'll mute, and then when we okay. That's it. And I'll remove the slide. So here we go. So okay, great.
Okay, look, Tuesday, we're back.
We're back. We're back.
Tuesday till.
Okay, so we can leave the door open. Doesn't seem to be much traffic, I guess.
Okay, welcome back, and we have questions from the chat.
Okay, let's get microphones back. Go ahead. Just on cables.
I know there's one for me and then the rest for our guests.
I've added the
Start
carpet.
with Lori.
Just a little extra. Warm things up. Oh yeah, here we go.
Will they be available all the time by webcast?
The CPDs, right now, we are on trial. This is our first one that is being offered by webcast. May and June will also be offered by webcast. That's MPAC Assessment Review Board is May, and our primer is in June, which is great for students, paralegals. It's a review of everything. Then July and August, we are off. So through July and August, what we're going to be doing is evaluating. We appreciate feedback, my email, Facebook. I'd love to hear from everybody. Recordings, we're not going to be available, but they are going to be available.
We can post a poll in the CIJS Enrichment Night. We can post a poll on Facebook.
Okay.
See.
Survey Monkey, we can do that. Good, Leanne, get on that.
I don't have enough work.
Are we done with the PowerPoint?
I think so, yeah.
Yeah, okay, because I'm just gonna.
So the recording of this, I don't know how long it will take. Lon has some great ideas, and we'll be working on that next week, and it will be available. And the powers that be still will have to set the price. That is not my decision to make, although I have fought for 4 years now to keep the price of these at $10, and I will continue. And it's as long as the powers that be allow it. Okay, so April, May, June, I can't guarantee 100%, but the recordings would be $10 also. But I can't say anything about next year's, and we'll be offering a greater selection of recordings. They won't necessarily be offered live. Okay, so then for our guests, their questions.
So Brian asked if there was a sample written submission that you wouldn't mind sharing, so they get a little bit of more insight.
Yeah, absolutely. We have a number of submissions ready to go, so we can redact enough information and get one of them out and post it up on the CIJS website, or Facebook, I should say. We usually just drop everything in the files portion, so it'll be free to anyone who would like it. Or they can PM Catherine or I.
And then the one last question was, you said that when they receive a client file, there were certain things that you look for. They wanted to know if you could provide some examples of what they should be looking for when dealing with the appeals.
It usually goes directly to the correspondence section and make sure that every piece of correspondence has been appealed and has met its timelines. That's the very first thing, going through, finding out what are the issues and have the timelines been met.
Mike?
Just a quick question. We talked a little bit about contingency fees, and I know there was some commentary about having too high. But what happens on the flip side when there isn't success and you put
All kinds of work into it?
Yeah.
7 years of work?
yeah.
Then you cry along with your client and you know, that's pretty much it.
Our retainers are a little bit different.
That's the way I do it.
Our retainers actually cover that. We actually have a stipulation that the client will still be responsible for disbursements.
Oh, yeah, there's that type of thing, but no, not.
Yeah, the parking fees when we get out to the WYSIAD and paper clips and so on, we'll charge to them then, but we hold off on all of those until the end.
Good point, because the Law Society meeting, it is the government on contingency fees, and the federal government wants to pass legislation. Oh, I think it's called the Bills of Tax Act. I will find out because it's part of the contingency involvement that I'm going to have at the Law Society. And basically what it is, think about it, SABs, WSIB, HRTO, you're not being paid until the final decision comes in. So the federal government, what we gather is they would like taxes to be paid before the final decision comes in.
What?
Every single year.
Really?
Yes.
Yeah.
Pardon?
Yeah. I plan on losing
That's the
every
whole thing.
case then.
What they said was, what you would do is you would pay, and this is only proposed. I'm doing a submission against it. Catherine, we're doing a submission against it.
We're doing a submission against it as
Yeah.
well.
But the point is that if then you lose and you make nothing, then you would apply to the federal government for a rebate
You've got to be kidding me.
on your taxes. So I don't know, like we don't know what awards,
No.
especially Human Rights Tribunal,
No.
we don't know what the award is gonna be. We might be claiming 100,000, we might get 40. So what are we paying tax on before the decision is made? So anyways, that, I'm sorry, I had forgotten that. That was another point made by the Trial Lawyers Association last night, that this is going to have to be aggressively fought, and it is going to be it's a non-lawyer apparently who is working on this bill, so it is going to have to be a major education session with this MP and on how contingency actually runs. I think the few that ruined it brought all of this to the forefront. Now we're all going to be paying for it, yeah, in a number of ways. So that was another thing with contingency.
That's ridiculous.
Yeah, caps, provincial, and taxes in advance of settlement, because we know WSIB, you can wait 3 years.
I've waited
4
more
years.
than 3 years.
Yeah, 4 years.
Yeah.
So are we paying as we go with receiving nothing? It doesn't really make much sense. So anyways, I'm not going heavy duty on that like the Bonkalo submissions. However, I will keep the paralegal community abreast of this as I learn more. I just learned about it last night, just the brief tidbits that I've given you. So.
Okay, we got a couple of cases that Leanne's going to chit chat to you about.
I'm going to jump back to contingency for a second.
go to contingency.
So contingency, I mentioned earlier, that's typically how you would approach it when you have a worker who comes to your door. We also handle unions. We have a union contract, and we send them a bill at the end of every month, and they pay out for whatever work we've done on their files. So they're fantastic because we don't have to wait on contingency with them. We can handle 15, 20, 40, 100 cases, and we just send a bill and get a payment. We also handle employers. And with our employers, depending on the size of the organization, we'll also send them a bill either monthly, or we'll get a trust payment up front, and that retainer will sit there and will whittle away, the same as we would with small claims. Much like landlords, some landlords are larger than others. We'll take a retainer. Sometimes we just send a bill. So contingency is one way to approach it, and with WSIB, there are really different ways that you can go about this. So keep in mind, it's not just going to be the worker coming to you and asking for help. With the union, we're representing the workers. With the employer, we're actually fighting against the workers. So there are different ways that WSIB can be handled. I don't know if you have any commentary on that.
No, I think you've covered it.
Okay. Anyone questions on that before we keep going? Okay. So there are a couple of recent decisions that have come down, and these are, well, one is a decision and one is not a decision. One is ongoing, but these are pretty monumental on the WSIB front. The first one is a gentleman by the name of Donovan. He died after being bullied in the workplace. This decision came out of Prince Edward Island. I will be posting on the CIJS site. We have the court side of things, a civil side where they tried to proceed. We have a 2015 case as well as a 2016 case where they've tried to proceed through civilly, and they were actually told that this was a workplace accident. They were redirected to WSIB and it's gone through and they won. So this is the worker's family who's gone after the survivors. And this is fantastic. As far as I know, this is the first time I've seen a case where bullying has won for survivorship. So
Yeah, it could be precedent
I don't know
setting.
if Mike or Matt have any other information on that, but as far as I know, this is a precedent-setting case. Again, as we mentioned, WSIB, it's not binding, so whether the WSIAT will take this case and use it if you need it, you'd have to argue pretty hard. But it's certainly interesting to see this kind of redirect to have the workers protected and their families better protected. Everyone is kind of saying that WSIB right now is very employer friendly, whereas it used to be very employee friendly. It's kind of shifted, and now this is almost looking like a shift back towards the employee. So maybe it will land in the middle, which would be nice. But I will be posting the two civil cases up there so that everyone can read those. The WSIAT decision I have not yet found. I've done a bit of searching, but I have not yet come across the actual decision. We do have a newspaper article, though, that speaks to it, which we can also post. I believe Mike posted it a little while ago as well.
An email went out to all of the attendees. The original email that gave the free information with that introduction that I taped, and I believe there was what was it called? Class resources, or
For the,
where the flyer was on the original
class plan.
class
The little
plan.
column.
Yeah. Okay. So everyone has the link emailed to them, the original link. So what I can do with those decisions, for those who aren't on Facebook, because I know there are people not on Facebook, is Lon can post those decisions in the class plan. The flyer is there already, and then anybody can have access to those. You don't have to log in.
We'll keep the web page on the, what we'll do is on the Global Class website, we'll have a permanent web page for this particular class where this live stream will be available with a password. So you have your email to get that password to watch it permanently, and all those resources can be posted on that page too. It'll all be in one place.
Okay.
Okay?
So the next case is actually Castrillo, and again, we don't have a case or decision for this because this is actually a class action that's being brought against WSIB right now. There's a gentleman who injured his shoulder back in 2011, and after a terrible go, he has now rounded up a bunch of other injured workers, and they're trying to get a class action together to go after WSIB. Between 2012 and 2014, they're alleging that there was essentially a secret policy that was redirecting the claims. So instead of having claims approved and paid out the way they should have been, these individuals are alleging that WSIB was disallowing all claims, and as Kat mentioned, there is a tsunami of appeals right now, and this class action, I guess, is trying to show that the appeals now are a result of the denied claims that should not have been denied. So it's definitely one to watch. We'll be following it closely. We'll post the article to that as well, and as we get more information on that, we'll keep everyone updated if that's...
I guess the decision from the motion.
Did you?
That allows us to move forward still. I also have the misfeasance tort that Richard Fink is relying on for that if you want.
Yes, please.
Send that forward.
Yeah, I'll email you and get a copy. That's awesome. Thank you.
My question is, so I read the case and the article in the Star. Isn't it about only those 2 years? Because it looks like they arguing about only those clients and those people who would deny those benefits from 2012 to 2014. What about now? Because those issues are still ongoing, like not about, injury to the shoulder or back, but still, this case is talking only about one issue, but there is a major one overall. They're not qualified to deal with medical conditions and overall, and there is a policy bias against. Is it going to influence it, or it's just, for those people who get into this gap of 2 years? Because I've been trying to figure it out and ask this question to everybody I hear about it, and if to be honest, no one can clearly answer it. So maybe you know.
I don't particularly. What do you think, Liam?
Well, I mean, we don't know until it happens, right? I mean, change is typically very slow. So decisions like this and cases like this are definitely going to assist in getting things sorted around. But ultimately, like I said at the beginning, this board has full discretion. Statutorily, they're allowed to do what they want. So whether an investigation or cases will start to slowly chip away at that authority, well, time's going to tell, right?
Thank you.
Any other questions?
So we're going to move into the duty to reemploy and the duty to accommodate. So with an injured worker, when they come to you, usually they're out of work, but that's not always the case. Sometimes they've been taken back to the workplace. Under the WISIA, Section 41 actually outlines the duty to reemploy an injured worker. So if at the time of the accident that injured worker has been employed for 1 year or more, the employer has an obligation to reemploy, with the exception of employers who have fewer than 20 employees. So that duty to reemploy comes with a duty to accommodate. If you want to jump in, I'm just going to ramble now.
You're good.
So the duty to accommodate is where, with WSIB, you almost want to be fairly comfortable and familiar with human rights as well. Because under human rights legislation, we have a duty to accommodate. WSIB has a duty to reemploy, and if that duty isn't met, well, now we've spilled over into a human rights issue, and this is going to go before the commission or the tribunal, and you need to make sure that you're in on your timelines for that as well. So you have a 1 year with the Human Rights Commission, 1 year with the tribunal. So when an employee is injured, I'm sure everyone's fairly familiar with the duty to accommodate up to the point of undue hardship. So typically an employee will say, I've been injured at work. The employer has full access to the claim file. They've read through the medical. They've potentially disputed it. And now they've terminated your employee, or they've refused to allow them to come back to work. And that's where Catherine and I will get involved with the second portion of their claim and take them to the Human Rights Board. With the Human Rights Board, we're now arguing and relying on completely different set of rules and law, and we're pulling case law surrounding Human Rights Tribunal and duty to accommodate there. So they have policies and guidelines and everything else. They're very clearly listed on their website. And the duty to accommodate, as I mentioned, applies to all employers. So even if you're a company that has 5 employees, you may not have to reemploy based on the WISIA, but you may have to reemploy based on the HRTO. So things get really fun and you get into a lot of crossover. So with us, it's one thing that we're always very mindful of, and we're constantly in touch with our clients to make sure that they haven't had any discrimination or they haven't faced any discriminatory actions. I'm going to let you talk, but I'm getting like a bit dry here.
So the employers are, let's say, enticed aggressively to return the employees back to work, some sort of accommodated work. If they do not, then their premiums, their fines they would be fined and responsible monetary-wise for the injured worker. So it's best for the employer to try and get the injured worker back to work as soon as possible. I have many injured workers who sit in the cafeteria and watch TV on their iPhones all day. But they are at work and the employer is paying them, and then that's all that matters. Okay, that's all. The employer is providing them accommodated work. There is a mandate saying that they have to have meaningful work, that they can't have anything sort of demeaning. It has to be something that is productive in the workplace. So when they get bored and get tired of just sitting in the cafeteria, that's when I start arguing for them to get different work. Okay?
Staying in constant communication is extremely important because you're going to end up in situations where, like Kat said, employees are sitting around twiddling their thumbs all day. Well, you have an individual who's injured. They're suffering financially because they had to take time off work. They're not receiving full pay while you're on WSIB. So they're financially injured, they're emotionally injured, they're physically injured, and now they're sitting in an environment where everyone around them is saying, he's not doing anything, or she's not working. Why aren't you working yet?
They don't look injured.
We're carrying the full load for you. And like Kat said, invisible disabilities are the worst because now you have individuals who look completely physically fit but are perhaps suffering from PTSD or some other psychotraumatic disability. You can't see that, and people assume that you're fine and you should get back to work. Well, now these people, it's creating a poisoned work environment. You have supervisors that aren't responding properly to requests for accommodation, and you have employees that are sitting there bored out of their minds. So that's furthering their disability in some circumstances.
It's contributing to depression, which leads to another benefit that you can ask for, which is a psychotraumatic disability. Because most injured workers are now going to suffer from some sort of depression, mental illness, panic attacks, going back to work, the poisoned work environment, anxiety. These are all things that you might have to address. Sorry, give me 1 second over here. Catherine.
I have a question from the chat. Someone wants to know if you add your billings all the communications while keeping in touch with the injured worker.
I'm sorry, I didn't hear your question, Catherine.
Someone wants to know if you add to your billings all of the communications while keeping in touch with the injured worker.
So again, typically these guys are on contingency. So we're docketing because we want to make sure that we're keeping track of our time. That helps us at year end to say this was profitable and this wasn't.
Yeah.
But we're not billing our clients because the clients get a percentage removed at the end of it. If it's a union or if it's an employer, then depending on the agreement that we have with that entity, we will be charging for correspondence.
But for contingency, no.
Yeah.
No. Sorry, was it Mike?
Sure. So in your experience, what's the role of the medical professional or their health treating practitioners in assisting with the return to work issues?
For me, the role of the medical, it's very important as long as I have independent medical. So for a lot of times I will send my clients to places like OCOW or LAMP. OCOW is the Occupational Health Clinic for Ontario Workers, and I'll get independent medical from them to support the return to work process.
They provide nice reports. With the medical medical advisors and there are functional abilities forms, and the functional abilities form is something that needs to be completed essentially right away. So from an employer standpoint, the first thing I'm going to do is get the functional abilities form done and find out what the limitations are. What can this individual do? Can they bend? Can they lift? How high can they raise each arm? What's the rotation? those things are very important because for us, representing the employer, we can assist them to get back to work a little bit quicker. From an employee standpoint, that's fantastic because now we have more medical documentation that's going to support the fact that our employee is injured. Our workers have a disability that's preventing them from performing certain job aspects. So the functional abilities form, we typically would want a functional abilities form done roughly every 2 weeks because it's, at least at the beginning, going to ensure that they're moving along and progressing. And from the employee standpoint, if they're moving into an HRTO issue, that's fantastic because now we're saying the doctor has said that this person is clear to return to work and you've prevented them from fully returning. Why? This is what the doctors have said. So we usually, I mean, with WSIB, you have to be very familiar with the medical terminology. Watch a lot of YouTube videos, watch surgeries, read medical reports, do anything you can. Yeah, you need to know what it means. We have doctors as well that we just consult with, and we'll call them at random and say, hey, this is the situation. Can you explain to me what the procedure is like? What is the surgery like? What's the recovery time typically?
A lot of the times what I'll have is I'll try and get a job description, a PDA, a physical demands analysis from the worker, from the employer, and have them take that to the doctor so that the doctor can understand exactly what it is, the mechanics of this person's job, how often are they bending, how often are they twisting, what are they lifting, and then the doctor can understand whether or not the person can actually go back and complete the essential duties of their job. So that's what I usually do, is get a PDA.
You have to be mindful of the functional abilities forms as well because the WSIB has a standard form. They have a standard FAF that they send out. I'll call it a FAF. It's an FAF that they'll send out, and the doctor completes it and sends it back to WSIB. Employers can also fill out their own form. They can have their own form sent to doctors. They pay the same fee that WSIB pays. It gets sent back directly to them, and then they have the information that they forward to WSIB. So with those forms, you have to be very careful because these are employers who are interested in getting either the employee back to work to reduce the premiums, or they're interested in getting rid of the employee because they're a troublemaker. So with these forms, it's now at their discretion what information they're requesting of the doctor. So you need to make sure that your employee is mindful of this and they're watching the forms as well to make sure that the doctor isn't asking anything that's too personal. The employer is not allowed to ask you what your official diagnosis is, but they can ask you what the surrounding factors are and how it influences your return to work. So you have to be very on top of the medical and make sure that you're communicating constantly. It's all about communication, I find.
It's a lot of communication. Another thing that Leanne and I are working on an HRTO case together, so we're kind of referring to this, the medical.
A little bit.
The medical, and if you can believe this employer did not want to take the employee back to work. Like, this is one that did not want to get the employee back to work, and we were arguing that this person can go back to work. And the amount of medical that the employer asked for was just
outrageous.
It was harassment after a while. 6 medicals, 6?
Yeah, I think we had 6
in a matter of 4 months. It was, and the questions were asked and answered it over and over again.
The doctor got to a point where he was saying asked and answered, asked and answered, asked and answered. We had one form go back, I think it was number 4, and 15 minutes later we got number 5.
Yeah.
So
we sent in number 4, 15 minutes later, number 5 was sent back to us. I want more information. So
working with the doctor is very important. Making sure that the doctor is looking out for your client is very important.
For the most part, the doctor is very, very supportive of the person's injury, unless the person's faking. And there's going to be people out there who are faking. It unfortunately
happens everywhere.
Society, it's their morals. They have their judgment day, but that's okay. Sorry.
So which preference then, if you had to make a decision on how you would like to proceed, whether you would go WSIB or HRTO, and under what circumstances would you be able to oust the WSIB?
under what circumstances would I be able to not do follow through with WSIB? But they're different issues, I think. So they're separate issues. For example, I had a WSIB case where the lady was did an LMR plan, which is now called the WT plan, work transition. Okay, but they never accommodated her for her learning disabilities. So I had an HRTO case for WSIB for discrimination against her learning disabilities. So I went through WSIB for her physical disabilities, her injuries and all that, and the HRTO for her learning disabilities for not accommodating her.
We have one on the go right now where the employee was injured at work and then he was terminated while he was on disability leave. So we've gone through WSIB for the injury at work, and we've gone through HRTO for the failure to accommodate, because this employer was exempted under 41.2, so he didn't have to reemploy. But under HRTO, we can argue that they had a duty to accommodate, and they made absolutely no attempt to accommodate, and we have written correspondence stating that. So we have an argument that's going to be structured in a way that's going to allow us to argue both sides. But you have to make an election form. You have to say we're pursuing civilly or we're pursuing through WSIB, and then it's up to them to give you a decision on whether or not they'll allow you to pursue WSIB. So it's a lot of forms.
It's a lot of forms.
Mm-hmm.
What else can I tell you? Let me think. Different benefits that you can ask for. You guys want to know about different benefits? Okay, so your loss of earnings is your basic benefits. That replaces your income that you've lost. Then there's healthcare benefits. That'll be your physiotherapy, your chiropractic, any sort of healthcare benefits, prescriptions, massage therapy, any sort of treatment that WSIB grants you entitlement to. From there, healthcare benefits, the travel expenses. Give me some more benefits, Leanne. Psychotraumatic disability is one that I try and get for my clients. Like I said, most injured workers will, after a while, go through a bout of depression where they feel like their injury has just totally consumed their lives. So I asked for a psychotraumatic disability.
We have NELS and FELS.
NELS, this is a non-economic loss award. Like I said, it stands, it's a whole body impairment, what they rate your body impairment to be.
So your knee might be worth 6%, your foot might be worth 3% or 10%. And you're essentially arguing that if your neck hurts as a result of a shoulder injury, you're going to argue that the shoulder should be worth a percentage and the neck should be worth a percentage, and the headaches that resulted from that should be a percentage. And you're going to start pairing up all of the different body parts until you get a big enough percentage to, as Kat mentioned earlier, either have someone deemed competitively unemployable or to get them a large enough percentage that it's worth your time and it's going to assist them. FELS also are worth mentioning.
Do you have a question?
Yeah, I kind of don't understand. It's basically like in SAPS, they have a specific chart that says this injury means this amount of percent. That's how it works? Or, like, I can have a, I don't know, like a neck injury, and my neck injury would look the same on, medically as to another person, but I would suffer much more. Like those kind of...
You're talking about thin skull.
Yeah, it's... How can they put like a number? So this is 31% and this one 32. Show me the difference.
They want objective medical, okay? So just because you hurt more than I do doesn't mean that you get more money than I do, because everybody handles pain differently.
Yeah, that's...
Right? So pain is subjective. But... For objective medical, things like, for example, a range of motion test, that's going to tell them exactly, you can only move your neck 15 degrees either way. Well, that rotation, according to the American Medical Association guidelines, is approximately a 10% whole body impairment. So they look at everything that you can't do, your limitations, your restrictions, and they add that up. And even though, like Leanne said, your ankle might be 6 and your wrist might be 3, that doesn't necessarily equal 9, okay? No.
No, it doesn't. I
In
know,
your
it's
whole body
crazy.
impairments,
Yeah.
it's the medical association, by the time they bring in this percentage and add it to that percentage, the whole body impairment is not equal to 9. It might only be equal to 7. Okay? See what I mean? It's
Okay,
just-
so if we're talking objective, so what about those cases when, the client lost a part of his body, let's say an arm, and
Yeah.
he had a phantom pain, or I don't know what's the correct way
No,
to
you're
say
right.
it. So, as much as I know, scientists doesn't know the exact, how can you estimate how much is it,
But they're not
in
looking
pain
at
if
pain.
there is no arm?
It's not about
But it's
pain.
not about pain. It's about she's lost the use of her hand now,
So
right?
there's no
Yeah,
fingers.
So there's no hand.
No fingers, no wrist, no no elbow, no shoulder.
But my
however far
question
you
is,
go.
the client is constantly in pain, so the client takes Advil or
Well,
something
then
else, and it's-
potentially you would go with a psychotraumatic.
Yeah, like-
if you can get to a point where you're saying this is affecting my daily life and I'm depressed because of the amount of pain I'm suffering, you could potentially turn that into a psychotraumatic disability. But there are limitations on that as well. How long after the injury arose did the depression start? If you're outside of the limitation period, you're not going to be able to claim that.
They're not looking at pain. They don't care that you're in pain.
No.
There's medication to help you deal with pain. Okay?
And you better take your medication.
If you have lost a wrist, like an arm to the top of the wrist, they're going to go to the guidelines and see what that impairment is. So, for example, I had a client who her hand was crushed. It wasn't amputated, but it might as well have been amputated. She couldn't use it. She actually had a metal bar that came up and supported her hand. Okay, she got a 47% now. Because that was, her right hand was considered, her dominant hand was gone. So that's how they measured it, according to the American Medical Association.
I have a gentleman paralyzed from the waist down in a wheelchair 24/7. He cannot walk or stand or do anything. Full-time care is necessary. He's at a 33%. So he comes in and we start arguing that he's worth a lot more than a 33%.
Let me answer the question, go ahead.
Now, does it include neurological?
I'm sorry, one more time, huh?
The now, does it include neurological?
Yes,
impairments? Okay.
yeah, they'll look at EMG tests and all that.
Hearing loss as well. Sight loss. All
Yeah.
of that is accounted for. Yep.
We have a question from the chat. It says, could we touch base on LMR and the suitability?
Okay, yes, LMR, suitability and the availability in the workplace is no longer called LMR. It's now work transition, has been for a few years. So work transition is offered for those where the employer cannot accommodate. The employer can't take you back to work. For example, I'll use myself as an example. I was a school photographer. I did graduations, proms, high school, anything you wanted to do with schools and photography. I was coming home from Ajax High School's graduation when I was rear-ended. It was a hit and run. And because I saw him coming, I braced for the impact, right? And that's how I got injured. So I can no longer carry my photography equipment. I can't carry my camera. It's too hard for me to hold it up, change backdrops, all that stuff. So I went through an LMR program, which back then was labor market reentry. Now it's called WT, and it's work transition. And what it is to get the employee back to work. Because once they get back to work, they feel useful again. They feel like they're a productive part of society. Okay? I stayed home for 2 years before I came to school. It was killer. People think, oh, you're home, you must love it. It's like, no. Okay? I watched Food Network for 2 years.
So she's an amazing cook, and her dog is extremely needy. That's what came out of it.
Okay? So work transition is to get you back into the workforce. I have been involved in a lot of work transition right now, and it's a much better program than LMR was. So what it does is they offer you either some sort of retraining or direct entry job search training that is going to restore your pre-injury earnings. So let's say you made $20 an hour, okay, doing as a truck driver. You can't go back to being a truck driver. So they're going to try and find you a job that you can do, that they can retrain you or direct entry with your skills, something that's going to restore your earnings to the best of the ability that you can, right? So, for example, my truck driver who is really badly injured, they wanted him to be a bus driver. A bus driver would be easier for him. He could just sit and open the doors, get out and walk around whenever he wanted to, okay? Because that's what it was, is going to restore his pre-injury earnings to the best that he had before, okay? Sometimes they get college programs. Very rarely do they get college programs. I am lucky enough that I was a paralegal college program, WSIB. I think there was 10 of us in class when I first started here. And I will tell you, back in an LMR program, and Mike, you might agree with me, there was no choice. You got told where you were going to school and what you were taking. And I don't know if that's I had no choice. I was told.
I didn't do the LMR.
No? Oh, okay. I had no choice. I was told this is what you're going to do. You're going to school. You're going to be a paralegal. It's going to restore your pre-injury earnings, and this is what you're going to do, whether you like it or not. Okay? So that's...
You'll end up in a meeting, and in the meeting, they'll sit there with you and your client, and they'll ask your client what their skills are. Can they use a computer? How long can they sit, stand? Do they have any woodworking skills or small engine repair skills?
Right back to high school, what kind of skills they would have.
You're 55 now. When you were in high school, could you repair a car engine? They go back through everything. So, in a few instances, we've had to battle against the work transition plan that they've wanted to implement. And through that search, we've actually only come across a couple of cases where people have been sent to university. Like,
I got one.
Yeah,
One
I think
who's
it's
sent to
an
university.
accountant, right?
No, she's a nurse now, but
Oh,
she
okay, I have an
made
accountant.
$33 an hour, so they sent her to university to be a nurse.
Yeah, this is
But very rarely do they get college programs, and if they do get college programs now, it's a 1 year, usually a 1 year program. It's not, unless they make a lot of wages or a high wage, they don't get a 2 year program. But it's much more inclusive now. Sorry, go ahead.
So, in your experience, how much deeming have you seen occur?
I've had quite a few deeming. I've tried not to. I argue it, but for the most part, I can get through it. I can get them justified as to what their retraining is going to be and what their limitations are.
And that's again where the doctors are very useful.
Yes. Okay. So when they come in, they get, like I said, they have a very extensive interview, and they will go through and try and find positions for you. You might have to go through psychovocational training. Psychovocational training is where you go in and they do all the testing of the patterns, how much you can read, your language, can you type,
keywording speed.
Yes, things like that. So psychovocational training, they will tell them if you would be acceptable to go into a college program if you're able to be retrained. And if you need any upgrading, do you need any computer upgrading? Are you going to be, like, for example, a 55-year-old truck driver and they're going to send you to college? Are you going to know how to use a computer? You might need computer upgrading before you go to school. Okay? These are all things that you might have to argue for entitlement for your injured worker. They might not being entitled to upgrading. Well, my client's not going to be successful if he doesn't have upgrading. Okay.
It's also very important that you prep your clients for these meetings. With small claims, and I mean even LTB to an extent, it's second nature. You know you have to witness prep. You know you have to talk to your client before they go into a trial or a hearing. With WSIB, every meeting has to be prepped because your clients are very upset and they need to be managed. You have to manage client expectations. You have to make sure that they're not going to go off the handle in front of a work transition specialist. You
Let them go off the handle on the work transition specialist.
Yeah.
I think you were there with me, Lori. He gets quite upset. I've had there's a high emotion there. These
They've
people
been refused and fighting for how many years?
Yeah, it's there's a lot of contention. It's interesting when you go into the board, you have to go into security and you have to show ID, and then you go to this one particular elevator that only you are allowed to use, and this security guard comes in and swipes you in and takes you up to the certain floor that you're only allowed on. And there you are met by security who checks you in. It's because the emotions are so high, it can be dangerous at times.
Wasn't one of the ones I went to, okay, I think, and maybe I'm wrong, the client was 62 or 63 years old, walked with a cane, and WSIB wanted him to, I can't remember what the job was that they wanted him to do. And he had been a truck driver, unable to work for a number of years, and yet we went to this meeting and they were ready to set him up to work.
Yeah, I just got him deemed competitively unemployable.
Oh, did you?
Yes, I've got two. I'm so excited. Yes, so he is 63. He's a truck driver, definitely. Just a knee injury. Knee injury turned into a knee replacement, which turned into another knee injury for compensation, which turned into a back injury because he's hunched over on two canes, which has turned into entitlement to his hands and his thumbs from holding the two canes. So I said, this client has been my client since 2013, but it just keeps growing and growing. There's entitlements to everything from there. So yes, his work transition, he was a truck driver, and that's all he's ever been, is a truck driver since the day he turned 19 years old. He's from the States, he's got a grade 8 education. They wanted him to go and be a shuttle bus driver for like going to the GO train and that kind of thing, you know what I mean? There was no way that this guy would ever drive. This man could never drive again. He can't use his knees for anything. He's had... Yeah, if you could see him walk, it was just unbelievable. So it took a long time of fighting, but his case manager was very cooperative. His work transition specialist, not as cooperative, but we were able to get him deemed competitively unemployable.
And the legal effect of that is?
That means he's not working, and he will be on full loss of earnings until he turns 65.
And those benefits are based on, I'm just asking for...
Yes, benefits are based on his earnings. So WSIB, for your first 12 weeks, looks back the last 4 weeks of your pay. They'll average out 85% of your net earnings. Sorry, of your gross earnings. Gross, thank you. I always get them confused. After 12 weeks, you're considered to be long-term, and they will do a reevaluation of your loss of earnings, and they'll go back the 2 years. Okay.
Well, what's interesting about that is that you sometimes have clients who haven't been working for 2 years. Mm-hmm. Kat had a crazy one where he was very, very young and he was very seriously injured.
He's Lori's favorite client.
And he was only employed for, I think it was a few weeks.
Your bank man.
Yeah.
I go to the bank with him.
So
he was only employed for 6 weeks in the construction industry, and a crane fell on him. He was severely injured, and he was only 23 years old.
He had a broken back?
Yeah.
What else did he have?
He had no kneecap. I have pictures of his kneecap on the stretcher beside him. He had a brain injury. He had it, you name it. A crane fell on him. What can you say? He was in rehab for years. And WSIB gave him nothing when I found him. He had nothing.
He
Not,
was homeless, wasn't he?
he was homeless. He wasn't even on loss of earnings. They weren't paying him anything.
So at that point, you're then arguing not that they should be going back the 2 years, but they should be going forward to what he would have earned. Because his potential for earning
I
was
was able to say that they shouldn't have gone back the 2 years, that it was prejudicial, because you're penalizing him for finally finding a full-time job, and he finally had a full-time job for 6 weeks.
They
right?
averaged him, didn't they?
They averaged him out, and he was making less than minimum wage, so they were paying him, I think maybe, what was it, $200 a month, I think he was getting?
Yeah, he was homeless.
Yeah. So we were able to get him on full loss of earnings, get him retraining, get him a non-economic loss because he didn't have a NEL award.
Can I ask a question?
Yes.
It's so interesting. So, what do you retrain him for? Or what can you, how can you get someone like
I'm
that
arguing that he can't be retrained because he is so angry. He has such psychotraumatic, like he is so angry at the world.
Yeah.
That I'm arguing that right now they're saying he can go out. They're frustrated with him. They've set him at minimum wage for 40 hours a week. He was making $33 an hour. I mean, this was a good job he was making. He was forming concrete. And then to go down to less than minimum wage at 23, he's got a girlfriend, he wants to get married, he wants to have children. How can he support a family on $200 a month that he was getting from WSIB? Doesn't qualify for CPP disability because he hasn't had a job long enough to contribute anything. So it was a really difficult case. I'm arguing that he's not retrainable.
So he's not trainable?
Yeah.
So what does he have now?
Right now he has full loss of earnings. At his $33 an hour because we're, 85% of the $33 an hour we got him. So, because we're in the middle of the work transition. So once we go through work transition, they will set him at a certain wage to hopefully restore his pre-injury earnings, which I don't think they will. So then they'll have to pay him partial loss of earnings. Yes, dear?
Just out of interest, is that income that they get, the 85%, is that taxable?
No, well, they have to pay, the taxes are already taken off.
Oh, okay.
Okay.
And that's different with unions.
Unions, you guys have collective agreements. I don't know what the unions pay. Go ahead, sweetie.
All right, yeah, I got like a bunch.
Okay.
One was if the worker qualifies for CPP disability, does it impact their entitlement to certain benefits?
Yes, it does. Not to certain benefits. It will impact their loss of earnings. So that will be clawed back.
And also, what is the criteria you need to meet to be deemed competitively unemployed?
Unemployable, the criteria? Off the top of my head.
Have a crane fog.
I had a crane. I had another one where a hydraulic garage door fell on him.
Oh, that poor guy. I felt so bad for him. I loved him.
Yes.
He was my favorite.
You know, you got to be able to show that you're just not retrainable, that
Yeah, you have no
with
skills.
your physical injuries, the amount of restrictions that you have, the psychotraumatic, if you're suffering from depression, panic attacks, anxiety, anything, all those significantly contribute to the fact that, you know, nobody's ever going to hire you. You're going to come in and you're going to say, for example, if you've seen the one that my garage door fell on, he looks like me, you would never know that this man was injured.
But
he's
inside,
got a
he's a mess.
66% now. He's a high now. He's in my serious injury program. So, you know, you look at him and you don't think there's anything wrong with him. But he is extremely angry that he just went off on the return to work specialist.
He was one of them, yep.
He was fabulous, actually. He was very articulate. And so, yeah, these things you're looking at, are they retrainable? Do they have the limitations, the restrictions that they can go out and do some essential duties of a job, anything, right? So like with Dennis, he's physically injured, but he's also mentally impaired as well. Okay. Another one?
Yep.
Go ahead, hon.
One person was looking for advice on a case. So they said that a worker was being offered entry into a Toronto rehab injury program for a battery of tests. They had multiple specialists. They wanted to know if there was anything to be guarded against or be aware of if he expects them to minimize any of his.
Could you tell them to private message me?
That's what I figured.
Yeah.
And then also for
Traumatic disability?
psychotraumatic, they wanted to know the criteria that you would have to provide, like if you needed, I guess, a doctor report or.
You do need a doctor's report, and you need to show that your medical for 5 years prior has not had, or has, whatever has, if you've had any other issues for the 5 years prior to asking for the psychotraumatic disability. And usually they ask for a psychologist's report, psychiatrist's report, okay? A DSM-4, DSM-5, whichever one, they might ask for that as well, okay? Yeah, Jordan?
So with regards to that, you can't have any prior history within 5 years. What if you already have depression, anxiety, but this injury?
Oh, no, I'm not saying that you couldn't have it for 5 years, sorry.
They just want to see
They
the
want to see your
records.
medical to see what it is. No, like, for example, my garage door guy, he had some previous depression as a result of his divorce, okay? So that was part of the DSM-4, workplace stressors, that kind of stuff, but they take it into account, but it doesn't mean that because he's had depression before that he's not entitled to it, okay?
We have a breast cancer survivor who obviously suffered pretty extreme anxiety and depression dealing with that. Injured at work, she's going to show depression and anxiety from this past experience. So that's when you start to get into pre-existing conditions. Was this an ongoing thing she suffered her entire life? Was it magnified by the accident? Did it stay the same? Same as any condition, really. If you go in and you tell them that you broke your ankle last year roller skating, and then this year you hurt it at work, is it the same ankle? Is it the same injury? Is it? They're going to look for a pre-existing condition because that's going to hurt your client.
Okay. Any other questions?
Can you explain assignments?
Assignments. For example, me, when I was injured, I was in a car, so I had the option of going through SAB, statutory accident benefits, or going through WSIB. You can't do both, no double dipping allowed, right? So I had to sign off my WSI or my car insurance claim and put everything to my WSIB claim. Now, if, for example, someone from, let's say the WSIB has denied entitlement and the client has had to go on to Ontario Works for help because they have got no money coming in. Ontario Works will have them sign an assignment saying that if they receive any sort of lump sum payment from WSIB, that has to be paid back to Ontario Works first. Okay, which is a good thing to think of in your contract, in your contingency fee contract, that you say that you want your contingency fee based on the amount awarded prior to any assignments, pensions, commutations, things like that. Okay, so if you're going to have that in your contingency fee, you want to make sure it's before any assignments.
Some people will also take future earnings.
Which is wrong.
We don't. We won't do that. These people are receiving 85%. Moving forward, they're already shorted on what they would have been making. Me taking another 10 or 15 or 20% off of that is just going to hurt them even more. So, again, that could be because I'm a bleeding heart, but to me, it feels dirty and wrong. So we won't take future earnings. We take a lump sum award and we walk. They don't need to pay me. Yeah, they don't need to pay me for the rest of their life. I mean, my partner once said to me, how many clients do you need with future earnings before you can sit on a beach and just keep cashing them in? It's not a philosophy that we we respect. And for us, we care more about the client than we do about our wallet.
And with
End
the
of the day.
SAPS investigation, and this goes to the contingency also, Provincial Level Law Society, rules of conduct, I don't know if it applies to WSIB. I do know it does apply in other areas. You may not take a cost award. So if the client is awarded $30,000 for easy math, plus $5,000 in costs, the costs are the client's. You cannot work that into your contingency. That was one of the things that sparked the investigation and the blow up in SAPS. And I'm sure it will just ricochet into WSIB, into small claims contingency, into HRTO contingency, HRTC, all of them. So be careful of your retainers.
That's such a limitation on access to justice. I mean, these people have a right to choose the representative that they want. That representative has a right to charge them what they feel is appropriate for that case, whether it's 20%, 30%, or more. That's the discretion of the client and the representative. And I understand that there may be an imbalance of power, but there are a number of representatives out there. These people have a right to go to any number of them and get a quote, if you will.
I spoke to one, though. This was about 2 or 3 months ago. That representative, it was HRTO. It was a small claim. And that representative, because it was a small claim, was justifying a 59% contingency fee because of the small amount of the claim.
You know what? At the end of the day, though, the court has no right meddling with the terms of a contract and what consideration is equal consideration. It's none of the court's business. So,
however,
if they chose to enter into that,
problem. Because now, because of these people at 59%, at 40%, of the ones who are taking the costs on top of the contingency, that's why now you have the provincial and the federal government's getting involved because of the media attention. And the media attention was caused by not the reasonable firms charging 15, 20, 25, 30%, even 35. I know one law firm, 2012, they were charging 35, taking cost awards, and 30% of all future earnings. So every check for the rest of that person's life was subject to 30% taken off the top to the firm. Now, the people should run because it's not assignable. But they didn't know any better.
I didn't hear you mention the issue where an employer is seeking cost relief. You have claims where the employer is either appealing a cost relief, SEIF, or they're trying to get one because of a secondary injury.
Secondary injury, well, that's there. What we're talking about is the SIF, the Secondary Injury Enhancement Fund, where employers can ask for relief because the injured worker had a pre-existing condition. Therefore, the employer was not fully responsible for the compensable injury. So they can ask for SEF relief, and that will usually be granted if you can prove that the injury is significantly contributed by the pre-existing condition, and then the case manager will assign a percentage of that claim to the Secondary Injury Enhancement Fund. Any questions? That was not me.
How do you find the employer?
See, Leanne does more employer than I do.
Sorry, what was your question?
The employer costs, how do you find them?
We always argue pre-existing. That's the first thing we go to. It's a go-to,
It's the first,
right?
yeah, standard.
I mean, immediate back to work, FAF, and a pre-existing. that's standards that go to. You don't want to pay. You don't want your premiums to increase because this person is injured. That's your goal, your end game. And it's not about the worker at that point. It's about protecting the employer's premiums. With that said, the employers that we take, because it's at my discretion, we take employers who genuinely care about their workers and they aren't out to gut them. They want to make sure that if the employer is legitimately injured, they're taking the time that they need. But typically the first thing we do is an immediate return to work, whether you're in for light duties or whether you're in for just a recon. And we're doing a recon analysis to pay you for the day to tell us what happened, because we need to make sure that you're getting back to work so that we don't have to deal with premiums. There's no time
injured
off.
workers receive an offer of modified employment the day after their injury.
Mm-hmm.
It is couriered to their house. Here you go.
We will pay for the cab to get you to work, and we will pay for the cab to get you home.
Mm-hmm.
We want the FAF done every 10 to 14 days because we want to make sure that we're accommodating you to the fullest.
Mm-hmm.
And yeah, it's a totally different world working for the employer.
Employers need aggressive return to work plans.
Yes. It's not just a per employee either. You need to have a plan in place to accommodate that. You know that with a larger business, we have an employer, they have over 200 employees. They know they have injuries. So they have an aggressive plan that deals with every portion of the company. And if somebody is injured here, they know exactly what they can do to cover that side of the business, to make sure that that person's job isn't putting too much weight on the other employees, and then that person is dealt with to make sure that the FAFs are done and they're back to work.
We had a question on the chat about if WSIB offers buyouts on future loss of earnings.
Not anymore.
And if it was only for pre-1990 injuries. Yes, okay.
Yes.
Wasn't that pensioning off?
That's way back when, yeah.
We also have issues with WSIB with overpayments. It's another big concern. A lot of clients will come in and say, I just got a letter saying I owe $200,000. What do I do? And then you have to start tracing back to find out when was the investigation supposed to start? Did the investigation start when they said it would start? Oh, we're done.
Sorry.
All right, well,
No,
it's
no,
nice.
Just a second, I'll reconnect it. So keep going.
It's been fun, guys. We're done. When someone comes in with an overpayment situation, that's an administrative decision, and that's something that you're immediately going to look back to find out why were they overpaid? Were they in fact overpaid? And if they were overpaid, is the number accurate? Typically in that situation, it's because WSIB, in my experience at least, has decided that there's been some sort of fraudulent activity. There's been a lie that's been told somewhere along the line, and then they're going to say, we're investigating, and then from the time of that investigation to the date of the decision, they're going to demand an overpayment be repaid, and then they're going to garnish you, and it's not going to be fun. It's another big one to watch out for. No, Kat's dealt with that with CPP as well.
That was CPP.
And remember, I dealt in real estate, WSIB, they put a lien, an execution on the name, and you go to buy, sell, or mortgage property, you gotta pay that WSIB off first.
Mm-hmm. Yes, they will prosecute you if they need to.
Yes, they will.
Okay, any more questions from the chat, the group? Okay, I'll close. Guess we'll go over here.
Well, thanks for having us, everyone. It's been fun.
Thank you.
I'd like to thank Catherine and Leanne, our Kim and Catherine, our lovely, wonderful chat monitors. We have our registration people, Denise, Next time, pizza, our usual pickup pizza person. And I'd like to thank everyone for participating online. I'm very interested in feedback, so please provide it. And thank you to everybody.
Feel free to comment on how attractive Catherine and I look.